I will start by saying something I said previously, that a will is a cornerstone of a good estate plan. And a will is a legal document, for starters, and it contains instructions as to what should be done on a number of things about a person. The first one can be the person themselves. So it will have like funeral instructions, burial instructions, about instructions about the person's property, assets, so distribution of the assets, how they should be distributed, to whom. And then it can also have information about instructions about maybe children that the person is leaving behind. So it's basically a legal document with instructions on what to do to the person, their assets, and any other thing like their children after they're dead. One of the main reasons we write wills is so that the people we are leaving behind are provided for. And not just loved ones, even other people who, if it was left to the law, they would not be provided for. So you write a will because you want to provide for dependents and also other people that the law would not provide for.
The testator has to sign the will. After they've written the will, they have to sign the will. And then a written will must have 2 witnesses. And again, these 2 witnesses must be also competent witnesses. And by competent, we mean these 2 people must be adults. They must both be of sound minds. So, and they have to sign in front of the testator.
Yes.
Right? They have to be 2, and they have to sign in front of the testator. So for people who, do wills, in the secrecy of their bedroom, and they write a piece of paper, and then years later you're giving a lawyer that piece of paper to implement, of course, that is not a will, because then it's only been signed, assuming that that person signed, it has not been witnessed, so it cannot be recognized as a written will. It's important for you to observe the choice of witnesses when it comes to a written will. That's because if you have 2 witnesses, and one of these 2 witnesses is a beneficiary under the will, their bequest or the gift that you've given to them might not be valid unless there are 2 other additional independent witnesses. And again, we're saying independent witnesses means people who are not a spouse to the person who is making the will and who are not benefiting under the will. Okay? So then it's important if you're able to get impartial people or people who are not benefiting from the will to be witnesses to your will, they are more preferable than you just making a will and then your witness is your spouse and your child, right? There might be more challenges proving the contents of that will than there are if you make this will in an advocate's office and then get 2 staff members in that office to witness your will.
2 weeks ago, we started a series here on the Wealth Tribe. I will be talking about estate planning. What is estate planning? Why is it important? And most importantly, what are the practical steps to start planning your estate, however small or however complex it is? And one of the tools that Olive introduced to us, or Olive and Wamuyu actually introduced to us, is wills. Yeah. And a lot of us have a lot of misconceptions about wills, and one of them being that it's for the wealthy. And today we are going to demystify those misconceptions and at the same time give you practical steps on how you can get started creating your will, how your will is going to be enforced, who has access to your will, and everything in between. And as always, I have Wamuyu on set to talk about this. And again, just like we had in the first video, Olive decided to join us again to have this conversation because she's actually an expert in this field. So we'll be hearing a lot from her. And as always, I'll give them an opportunity to introduce themselves. Wamuyu?
Thank you for having us again, Agava. Again, as we said in our last video, we are very excited about this series on estate planning because of course it's something that tribers have really been asking for, and it's only fair that we have this discussion. So again, my name is Wamuyu Kajere. I'm excited to be back here to have a more in-depth discussion about wills.
Olive?
Hi everyone, it's a pleasure to join all of you again. My name is Olive Wanjiku, and I am very excited to be here to talk more about wills and how to get started with your will.
Okay, and Olive, now that you're the last person to introduce yourself, let's kick the ball rolling. What is a will?
I will start by saying something I said previously, that a will is a cornerstone of a good estate plan. And a will is a legal document for starters, and it contains instructions on as to what should be done on a number of things about a person. The first one can be the person themselves. So it will have like funeral instructions, burial instructions, about instructions about the person's property, assets, so distribution of the assets, how they should be distributed, to whom. And then it can also have information about, instructions about maybe children that the person is leaving behind. So it's basically a legal document with instructions on what to do to the person, their assets, and any other thing like their children after they're dead.
Okay, that's very new information, because I always thought that a will is all about my property and who will get what. Now I know that in my will I can include, this is how I want to be buried, right? This is what I want. This is how I want my funeral to be conducted. And so we are always learning here and building more and more information. And so obviously, when you bring out the conversation about wills, there are many misconceptions and myths, right? And there are people who will say, all of us know, when you bring wills to the table, the first thing people think is that you're calling death, right? It's the same thing when we talk about life insurance and you tell somebody to get life insurance for their beneficiaries. They start telling you that that's a way of calling death. So Amoyo, is having a will, if I write my will today, does that mean I'm calling death?
Well, that's a very interesting question because, of course, that's based on your personal beliefs or whatever. But I believe it. I believe it's a myth, because we have so many people that have written their wills and they have lived 10, 20, 30 years later. I mean, unless there's statistics to back up that theory, then really there's nothing to it. So no, you preparing, for your death, or just, preparing how your children or your family will be taken care of after you're gone, would say to not do it would be reckless. Yeah, to not do it would be reckless. So then no, it's not calling death up on yourself, because again, there are no statistics to show that. Yeah.
And what other misconceptions and myths do we have surrounding this topic?
I think the obvious one is that people think that you have to be super wealthy to write a will.
Yes.
And no, you don't need to be super wealthy to write a will. You can write a will for whatever it is that you have, because what we have seen is that you would think that the estates or the families that fight so much in court are the families that have so much. But you'll be surprised when you go to succession courts and see that some of the cases that also go on for years are estates that barely have anything. The little that is there, because everybody is trying to have a piece of it, it can still create problems, right? So no, you don't need to be super wealthy to create a will. If you have 2 plots of land, do a will for those. If you have several bonds, make a will for those. I've seen even in my own family, instances where even something as little as employee benefits, or I don't know what they call that package that they give once. I have had a family member who passed on a couple of years ago, and there was a payout from the company where she used to work, and you would think that something as small as that wouldn't create chaos, but the kind of chaos that were in that house, when now this company needed a name or a bank account for where to transfer the money to, you'd think there would be no chaos for that. But the amount of chaos that was in that kind of family, because then, of course, without going into details because of the privacy of these people, suffice to say there was so much chaos for what you would deem like a small thing. So yeah, so you don't really need to be super wealthy to make a will. Whatever it is, whatever little you have, make a plan for it. As long as there's somebody who depends on you and you want that thing to benefit that person, and just make a will for it. Yeah?
Yes.
Yeah, so that's the other thing, that you need to be super wealthy. The other thing is that people think that now when you write a will, then that's it. And that you don't get an opportunity to change your mind. But no, you can write a will and you can change it at any time. You can amend it at any time. You can cancel it at any time. You can destroy it at any time. Literally, for as long as you're alive, the choice is on you. You can even make a will today, give someone something, the next day they annoy you and you feel like you cannot stomach them, and you go and you amend the will or you cancel it. So yeah, just because you've written a will doesn't mean that now you are bound by whatever it is that you have written in that will. You can revise it as many times as you need to. The other thing we have already discussed, that people think that wills is just about whatever it is that you are leaving behind in terms of asset, but we've seen that it's a bit more. It can cover wishes of how you'd want your body to be disposed after death, and some people take some of these things very seriously. There are people who have a specific place that they would want to be buried. There are people who want their ceremonies to be carried out in a certain way. And we've seen those things. So yeah, if you have very specific wishes or you're very passionate about something, you can always get your wishes observed. There are even people who've written wills and say, don't fundraise for my burial. I've seen that. Because, maybe they were in a scenario where they saw a fundraiser for a burial and they thought that this is not dignifying. Yeah, and they put an account for whatever, they made provision for how they would be buried, and they made say there would be no, fundraising. Again, and most importantly, if because sometimes if maybe you have minor children and you foresee, there are circumstances that also happen in life which make you actually foresee death, something like a terminal illness. There are certain types of cancers, and depending on what stage that cancer is at, and depending on what the doctors are telling you, you can know that, maybe I'm not going to be there in the next 5 years and I still have minor children. Instead of just leaving it to, vibes and inshallah, you can make wishes on, I would want a certain person to take care of my child. And of course, as Olive advised us in the last video, it's also important to have a discussion with the person that you intend to bestow that role, so that as long as they are okay with it, then you can express it in your wishes. And the important thing, even if you have had an oral discussion about it, the important thing of the thing that would mentioning it in your will would make it also easier on that person as a guardian, because one, there's paperwork they can use to formalize things. Because I remember a couple of years ago, there's an opinion that I was doing where there's a certain lady that had sort of adopted, not, I wouldn't say adopted, but had sort of taken one of the grandchildren as one of her own, and she wanted to be responsible for this child, to take her to school and all that. And at some point she needed to include this child in her medical insurance cover. And for people who've dealt with some of those processes, they're not easy when you don't have the paperwork, right? Yes. So even for things like that, so for someone who has been mentioned as a guardian in a will, it will be easier for them to also apply for legal guardianship in court, and be able to formalize some of that paperwork if it's, you want that child to be, included in your medical insurance or something like that. It just helps the person you've left in charge to be able to maneuver things. Then again, there are some people that think that once you make a will, that's it. It's cast on stone. Your wishes have to be observed. End of story. It's not automatic that will happen, because we have instances where wills get invalidated. Like you leave a will, and for you, you've left a will, and those are your wishes that will be, respected and observed. But sometimes it doesn't happen. And instances where wills get invalidated, one is if you don't follow the formal requirements, because our law prescribes for how wills should look like, or how they should be done, how they should be witnessed. So of course, if you do not observe some of those things, again, a will can be invalidated. So it's possible for you to make a will and your wishes are ultimately not observed. Again, we have instances where people make wills and maybe fail to provide for their dependents. There are instances, and of course this has to be dealt with on a case-to-case basis. There are instances where a will can be invalidated on account of not providing for people that are dependent on you. And again, some people think wills you can only bequeath your family. But no, with wills, you can bequeath whomever
You yes.
or whoever it is that you want to bequeath, as long as you also take care of your dependents, as long as you've provided for people that are independent on you, you can also, you can bequeath on anyone. We've seen people bequeath their house managers. We've seen people bequeath, children's homes, charitable institutions. So you can do all those things through a will. So a will is not just to provide for the people that are related to you by blood. So yeah, those are, I think, some of the misconceptions that I can talk about. Yeah.
That's very important information. It's important that you mentioned that you can't just bequeath anyone and leave your children unattended, right? So, and before we dive deeper into also wills can be invalidated, before we talk about that, Olive can teach us, why do people write wills in general?
People write wills for the biggest reason, and we said this in our other video, in our previous conversation. It is a matter of exercising choices. It's a matter of, you have lived your lives making choices. You might as well have the opportunity to make a choice about how you like your life should go, or about how things should continue when you're gone. So it is about making choices. It is about choosing how you want your assets to be distributed, how you want your children to be cared for, how you want you yourself to be treated when you're dead. There's some people, as Wamuyu has said, I don't want to be buried, cremate me. So if you don't give these instructions, then people will make that choice for you. They will bury you when exactly, and what you wanted was cremation. So, and then another, just to follow up on what Wamuyu said, is to provide for dependents and loved ones. One of the main reasons we write wills is so that the people we are leaving behind are provided for. And not just loved ones, even other people who, if it was left to the law, they would not be provided for. So you write a will because you want to provide for dependents and also other people that the law would not provide for. Another reason is make succession easier on your family. We said it before, we're saying it again. We've seen cases where if you deal with a convoluted succession, Agatha, it can drain you so much. And then the thing that sometimes people forget is that when you die, not only do your dependents and your beneficiaries have to think about what happens to them, there's also grief. And grief is hard. So you're making people move around courts. People are moving around courts. They are grieving. Some people even get to some point and they're like, I am tired of this process. Let it end. I don't even want anything to do with this property again. So if you want to make succession easy on your family, it is better that you have a will, because then they just go to court and then the court will follow your instructions unless there are challenges or objections. Another reason is to disclose information about assets and liabilities. Sometimes we are a very secretive society. You have a property that you have bought, you don't want anyone to know, but you don't want it to be wasted. So a will can be a very valuable tool of disclosing the things you have, so that your family and the people you're leaving to know what to follow. If you die without writing a will and there are some secret investments you had made, then they're not going to be followed up because they don't know. So it is a very good tool of disclosing the things that you own, your liabilities, so that people know what it is they're dealing with. So those are some of the reasons that people write wills.
Yeah, that's indeed true. Especially, the most important thing about this conversation, even if you haven't started the process of creating your own will or doing your own estate planning, you've had stories. So no matter how many examples we give, you know the truth, right? So it's a matter of understanding that it can happen to you or your family or your loved ones. So it's very important for you to take actions. And so, and as we were having this conversation earlier, I was shocked to know that there are actually two types of wills. I didn't know that we have oral wills. I always thought that a will has to be written. So maybe you can educate us more on that.
No, we have oral wills. Our law recognizes that somebody can make an oral will where they just, state out that I want this and this and this and this, and it can be respected. Now, it's I would call it a special circumstances will, because one, there are limitations to oral will. Again, in as much as we're saying they're recognized under the law, you can just make them anyhowly, and they're given effects. First, if you want to make an oral will and you want the oral will to be enforced, One, you have to make it in front, or you have to have two competent witnesses witness your oral will. And by two competent witnesses, I mean these two people have to be adults, have to be both adults, and they have to be both of sound mind. So they have to be two adults of sound mind. Again, if you make an oral will, the only way that oral will be recognized as valid and enforced is if you die within 3 months. Okay. From the time you make the will. I know it sounds funny, but that's the law. Yeah, you just have to die within the 3 months.
Oh God.
Because basically this requirement is because it's not something that is encouraged. Of course, people are more encouraged to do written wills, but because the law recognizes that there can be circumstances which make it harder for people to do a written will. For instance, maybe it's an accidental sort of, maybe someone has they've gotten an accident, they're in the hospital, they're bleeding their lives out. They know they'll die in the next couple of minutes. And and maybe their wishes they would have wanted for them to be enforced, and they don't have an opportunity. As much as they would want to do a written will, in that particular moment, they don't have an opportunity to call their lawyer and start drafting the will. So under those circumstances, if they can get the necessary witnesses that are required by the law, they can still spell out whatever it is that they want to be their wishes, and that will be observed. So those are the two requirements. That one, this will has to be made in front of two competent witnesses, and two, it can only take effect if you die within 3 months.
Yes.
Because now the assumption is, if for instance you live beyond the 3 months, then maybe it wasn't an emergency.
Yes.
So then it will be taken that you probably have the opportunity to, put down a proper written will. Now, the challenge again with oral wills, which is why we also don't recommend them, is because this is something that was spoken and there's no record of it, there's no reference. It's possible for the people who have witnessed to not have the same account of what you've said. Whether it's deliberate, whether it's by mistake, it's possible that I make a will in front of you two people, and then 5 years later, when you are doing the enforcement, you're saying one thing and you're saying the other. It's very possible because, again, human memory, and sometimes also there's mischief. So then what happens is that if there's contradiction between the two people that witnessed the will, the only other way that the will be recognized as valid is if there's two other additional independent witnesses.
Yes.
And independent to mean that none of those two people can be a spouse to the person who made the will. No, a person who makes a will is called a testator. The two people, it cannot be a spouse to this person, and it cannot be someone who is inheriting from this will. It has to be like two impartial, independent people who will say, yes, you guys are contradicting, but for me, what I heard is this. So if those two people have the same information, and then they corroborate what either of you is saying, then that can be observed. Which then means if there are no two other people, then that will not be considered as valid. However, for the military people or people who are in active service, there's exemption. You remember that rule that we've talked about, that you have to die within 3 months from the date that you make that will? There's an exemption for people who are serving in the military and they're on active service, because then it's taken to, it's understood that those people are in circumstances which might make it harder for them to make written wills compared to the civilians or to the ordinary people who, have a flexibility and mobility. Yeah, so that is it about oral will. So as a summary, it has to be made in front of two competent witnesses, and sometimes there's need for two other competent witnesses if there's contradiction between what these two people had or reports. And again, the death within the 3 months, except in the cases of a military officer who is serving active duty. Yeah. So that's pretty much it about oral wills that we don't recommend, but in an emergency situation where, you maybe you have a loved one, or you are just in any situation where there's an impending death for one reason or the other, and there's no opportunity to make a written will, you can make an oral will, but just ensure that you have at least 4 people, 2 of which are not your spouses or people you are bequeathing. So you can even call a nurse if you're in a hospital kind of setup. You can call a nurse, a doctor, and maybe 2 people who are your family members. So with the 4 witnesses, your wishes can still be observed and your will can still be recognized and enforced.
Okay.
Then now we move to written wills. Of course, written wills by its definition means it's written down. So of course, there's no requirement whether, it can be typed, it can be handwritten, whatever. As long as the will, once you write the will, whether it's handwritten or typed, the testator has to sign the will. After they've written the will, they have to sign the will. And then a written will must have 2 witnesses. And again, these 2 witnesses must be also competent witnesses. And by competent, we mean these 2 people must be adults. They must both be of sound minds. So, and they have to sign in front of the testator.
Yes.
Right? They have to be 2, and they have to sign in front of the testator. So for people who, do wills, in the secrecy of their bedroom, and they write a piece of paper, and then years later you're giving a lawyer that piece of paper to implement, of course, that is not a will, because then it's only been signed, assuming that that person signed, it has not been witnessed, so it cannot be recognized as a written will. It's important for you to observe the choice of witnesses when it comes to a written will. That's because if you have 2 witnesses, and one of these 2 witnesses is a beneficiary under the will, their bequest or the gift that you've given to them might not be valid unless there are 2 other additional independent witnesses. And again, we're saying independent witnesses means people who are not a spouse to the person who is making the will and who are not benefiting under the will. Okay? So then it's important to, if you're able to get impartial people or people who are not benefiting from the will to be witnesses to your will, they are more preferable than you just making a will and then your witness is your spouse and your child, right? There might be more challenges proving the contents of that will than there are if you make this will in an advocate's office and then get 2 staff members in that office to witness your will. Okay. It's easier.
Yeah. So an advocate is one of the people who can be an impartial witness to your will. That's what you're saying. Yes.
Absolutely.
Okay.
Yeah.
All right. So, and is that all the information we need to know about written wills?
Pretty much, right? Oh, as long as you observe those 2, of course, when it comes to the actual practice, there are guidelines that you need to follow in terms of, and it's more of best practice. But the legal requirements is that if it's written, it has to be 2. You have to sign as the testator or the person making the will. There has to be signature. And this is wet ink, I think, because by the time this law was being made, right now we are revolutionaries. Now we are doing digital signatures and electronic signatures and all that. But by the time this will was made, of course, the signature that is intended is a wet ink signature. So it's important, if it's a typed document, print it out, sign it with wet ink. Get witnesses to sign it with wet ink, because then I wouldn't encourage anyone to try and venture into digital signature or electronic signature for such kind of a sensitive document, because there are always cases of forgery in court, and it's easier to verify a wet ink signature than a digital signature, and either way, the law did not recognize digital signatures at the time that law was made.
Okay. Yeah. Okay. All right. So all these things you're mentioning is like caution about making sure that our written wills are legally valid. And so then Olive will help us understand what constitutes a legally valid will.
So when we're talking about legally valid wills, we know that the wills that the law recognizes, both oral and written. So one of the key elements of a valid will is that it is written by an adult of sound mind. And by sound mind, I mean you need to be able to understand what you're doing. What is it? What is this thing I'm doing? This bequest, why am I doing it? You need to understand the action that you're taking. So that is what we mean by an adult of sound mind. And some of the challenges and some of one of the ways that a will can be challenged is someone bringing evidence and saying this person was not of a sound mind at the time they were making the will. So we can advise, if you, for instance, if you have a parent or someone who wants to make a will and you're starting to see signs of, this person's mental health might deteriorate to the point where they might not be able to be of sound mind, take action. I would advise get a medical report before they do the will and have it certified that at the point of that making that will, the doctor and anyone else who looked at them could see that this person was of sound mind and they could be able to understand what it is they're doing. So this is a caution to people whose maybe parents or people who are starting to see signs of maybe I might be mentally incapacitated in a short time. It is advisable to start now when you're still lucid. And then another element is, of course, what Wamuyu has said, the formalities. If the formalities are not met, because these are legal, they're legal requirements, and the legal requirements are put there because there's a safeguard. There's a safeguard that needs to be, there's something that the law is safeguarding. So the formalities have to be observed. The formalities being, if it's the formalities of an oral will, they have to be observed. If it's the formalities of a written will, they have to be observed. And that's why we advise people consult experts, because they know these formalities and they can be able to tell you, actually, if you come to me and you tell me, I want my wife and my child to witness my will, I will warn you and tell you, actually, it's better that we do this because of a certain formality, that if we use your wife and children as witnesses, then it might lead to challenges in the future. So those are the two major elements of a will that is can be termed a legally valid will.
What about something you had mentioned that earlier on, that a will has to provide for my direct beneficiaries, right? Because she had mentioned that what if I just give all my property to my friends?
That's true, and it's something I have left out. You have to. That's why we talked about taking stock of your life. Figuring out who it is you want to bequeath, who are your dependents, who are your beneficiaries, because there's a possibility that if you leave out someone, a dependent, and that's provided in the Law of Succession Act, there's a very interesting section called Section 26 that lists out who dependents are, and it's very tricky. So you have to make, you don't have to give them everything. What the law says, a reasonable provision. What you can see is reasonable to this person, so that they don't have, if you go to court and then if someone comes to court and they start telling the judge, I wasn't given 1 million, but the judge can see that according to the circumstances, maybe your relationship with this person, what the testator left you was reasonable. So we're not saying that you have to provide a lot for all your dependents. You just have to reasonably provide for them, because then if you don't reasonably provide for them, depending on it, these things are decided on a case-to-case basis. The court can actually say, you know what, actually, out of your estate, even if you have already given it out to so and so, we are going to make a reasonable provision for this dependent. When we were studying the law of succession, I remember there was a case where the court awarded someone, I think it was either 10 shillings or 1 shilling, a very nominal amount, and the court said, this is reasonable. You wanted to be provided for, we have provided for you. So that's very important, the issue of dependence. So reasonably provide.
Okay, that's very important by then, because you can't then just decide. It's like the law is teaching adults to be responsible. Don't have children and leave them nothing, and at the same time, let the kids not have these elephant expectations of my parents has to leave me X number of millions, or I am entitled to X property. It's like the idea is reasonable. Yeah, that's very important, and that's again why it's important to consult a professional, because then they will give you. Because I didn't know this information, right? Maybe I would feel like, because as a parent, like I feel between a rock and a hard place, I have to leave my child everything, right? Because they're my dependent. Yeah, so that's very new information. But as you're saying, using that tangible example is hilarious. It's like, you wanted something, here you go.
No, I think the bit with that provision is where, because of course there's been scenarios where people, I happen to have 3 children and then I'm not in good terms with one of them, and I decide, you know what, you disrespected me when I was alive. Why should you have a taste of anything that I owed? So that person decides that they are going to give their everything to these two other children and leave this one out. Now we have had cases where now the person that has been left out goes to court after, everything and says, you know what, my father didn't leave me anything. And we've had cases where a will just gets invalidated on that basis only because, and especially, and of course, the law gives, first of all, our Kenyan law specifically gives a lot of discretion to the judge who, that case goes to, because for them to decide whether they're going to invalidate this will or they're going to provide that you get something, again, as Olive has mentioned, it's been termed as a reasonable provision. So it's the court to decide. Are they going to disregard you totally? Are they going to order that you are provided something out of this will? Are they going to invalidate this will in entirety and tell you to go to intestate succession? It depends on many circumstances, and the judges have been given a lot of discretion. And some of the factors that, the judges are told to look at, first of all, look at what are the needs of this person. Of course, for someone who is already set up in life and they have an income and their life is going on, they were educated. If your parent took you through school and now you have, you're at a position where you have a job, you have an income, you have your life going on for you, you cannot be looked at with the same lens as a child that has been left, say, in Form 2.
Yes.
Yeah. So it's easier for a judge to disregard this person, but they cannot disregard someone who still needs school fees to get through school, who needs to get something. They need more. So of course that's one of the reasons. That's one of the factors that the judges are told to take into consideration. That's the needs of the person. They're also supposed to take into consideration your relationship with that person, because it will be inconceivable that you just decided to leave out a child who you never had any issues with. It's understandable when you had a rocky relationship or the relationship you had with that child was strained. It's kind of understandable. But when you just leave out a child out of spite, there's no possible logical explanation as to why you left out the child. It's likely that the judge will make provision for that child who there's no logical conclusion for why they have left out, compared to someone who there's probably even evidence in court about how they were disrespectful, how they were entitled, how they maybe treated you badly. Of course, those two people will be treated differently. For the judge to decide whether to invalidate the will or whatever decisions to make. The other consideration that the court will look at is whether there had been any advancement. Well, this person was alive. Had they advanced you anything? For instance, when this parent was alive, they probably gave you a rental property somewhere where you're collecting rental income everywhere. Of course, you will be judged differently compared to someone who had not been left anything. So those are some of the considerations that the judge will look at to make a decision whether a reasonable provision should be made out of the estate without invalidating the will, or whether the will be invalidated, or whether it will be given 10 shillings. There's a lot of discretion on the judges on this one. So yes. So and of course now we're saying those cases, it will be tackled on a case-to-case basis, because then you see ultimately it's the judge's discretion. There are other reasons why wills can get invalidated. Of course, we've talked about the formal validity, the signing and the witnessing. Of course, if they have not been observed, a will can easily be invalidated, where now if a will is invalidated, then basically you are being told there's no will here, go and do intestate succession, where now you will follow the default succession provisions. The other big reason why most wills get invalidated is if there's evidence of fraud, if there's evidence of coercion, if there's evidence of importunity or mistake. Let me go through them one by one. Fraud would happen in the event where somebody has been fraudulently induced to make a will. Either I have come and lied to you about something and then induced you to make a will. It's not something that you would have ordinarily made if I had not pulled that stance. Again, importunity is where you pester someone so much, they make the will out of annoyance than out of wanting to make the will. Again, if there's evidence of that this person was pestered and made, you make someone's life miserable until they're writing a will just to get rid of the pestering. Again, if there's evidence of something like that, it can lead a will to be invalidated. Again, mistake. If you're mistaken over anything at the time you're making your will, maybe you're making a will and bequeathing something to a child, thinking that it's your child, and then it turns out they're not your child.
I was about to ask, what do you mean mistaken? Okay.
Yeah, so any sort of mistake that can be, basically whatever it is that it's not what you intended to do. A will needs to be what you intended to do.
Okay, yeah.
Right? So anything that could take away that free will, yeah, it can be, if there's evidence of that, it can be used to invalidate a will. And there are very many cases. In fact, you'll see amongst the cases that, amongst all the objections you will find trying to invalidate will, the fraud coercion is usually like number one there. Yeah. But of course, there's the other bit of proving that there was that. And of course, the courts don't operate on words of mouth. If you're saying that there was coercion, show there was coercion. If you're saying there's fraud, prove the fraud or prove the fraudulent act.
Yeah.
Again, if a will is altered and there's no reasonable explanation for the alteration. So if we find, as Olive says, wills are, we'll explain later, wills are usually sealed. There's a way you seal so that if there's alteration, you can tell. Now, if there's alteration in a will, where, for example, I had written John to get 10 million shillings out of my estate. And then the 10 million, see, there's 10 and then there are 6 zeros. If there's an alteration like where two zeros are cancelled and there's nothing, there's just a cancellation of 2 zeros or an X on the 2 zeros. And there's nothing, there's no countersigning, there's no nothing to explain. Was this deliberate? Was this intentional? Did somebody else sneak in and do this cancelling? Yeah, so if there are challenges like those, again, a will can be invalidated. It needs, if there's such a cancellation, it was done by the testator, there needs to be countersigning by the testator and both witnesses to show that this was an intentional alteration. The other reason why a will can be invalidated is if you make a will, then 5 years down the line, you marry. That will cannot continue to be valid. Why? There's a circumstance that has happened that has legally altered your status, that has legally altered your dependents or your beneficiaries. Unless the only circumstances where a marriage that you procure after a will not be invalidated is if in your will you had foreseen this marriage, you had contemplated the marriage, and it's a marriage to a specific person. You can't just say in my will, in the next 2 years I will marry. Full stop. No. It has to, that you are contemplating you will marry, and specify the specific person that you will marry, so that it's clear from the will that you knew there was a circumstances that was going to come that would alter your legal status and that would alter your beneficiaries.
Okay, yeah.
So those are some of the reasons why sometimes people will do wills and then later on you hear, oh, that will was invalidated, now they're doing intestate.
Yeah.
Those are some of the reasons why.
Okay. Yeah. And so now Olive will teach us how wills are enforced, because clearly now we'll assume that, for example, Agatha's will is not invalidated. So if I came to you as lawyers and my will, a passed on my will is not invalidated, how will the will that I wrote through you, for example, because now it has to be legal, because we've known it has to be an independent someone, and that person, impartial, independent someone, and that person, for example, can be an advocate. So how will it be enforced? Actually, I've never thought about that. How are our wills enforced?
So first of all, the enforcement of a will, everyone should understand that enforcement only happens on death.
Okay.
So that's the first thing. The person should be dead. The will that you're trying to enforce, they should be dead, and there's need for proof. There's proof of death, so you have to have a death certificate. And our law provides for the practice is that the people also have to procure a letter from the chief, from your local chief. So it is the chief that will say, actually, this person, I knew him. He was in my village. He had a wife. He had 3 children. They have come to, these are them. There's need for that formality. So the first thing is enforcement is upon death, and there needs to be proof of death, death certificate, and a letter from the chief will be required. And then before we even go to enforcement, I think it is also important for us to understand what happens when you've written a will. So you've come to us, we have drafted for you a will. We have ensured that it has been signed. So a practice we do is we seal the will. So there's a special way in which we seal it, and you, as the testator, you will sign on the seal. So that if, for instance, someone, if it's not you who has altered and someone else, because we've said that all alterations need to be, countersigned by the testator. So if someone else has altered it, then the will we can be able to see from the sealing that the tearing of the seal is part of the evidence that this will was altered against the testator's will or choice. So that's the first step. So there's need for sealing. And we recommend that you as we said, part of estate planning and part of making wills and part of planning our demise is communicating. So it is important that you communicate to your executors. Tell them, I have written this will, I have named you as my executors. The will is stored with my advocate. The will is stored in a safe deposit box so that they understand. So the executors are the people you name as the ones who will enforce that will. Okay. So you say in your will, I am naming Agatha Wanjiku and Monica Wamuyu. They are the ones who are going to go with this will to court. They are the ones who are going to sign all the documentation. They are the ones that are going to be given authority by the court to follow my instructions. So if it is, and they will usually get a document, it's called a grant, right? A grant of probate. So with the grant of probate, it is given to the executors and then they use it to enforce. So if it's lands, you had said, I want my property to go to my wife. The executors are the ones who will sign the transfer documents saying that here is our grant and we were given the right by the testator to enforce the will. So those are your executors. Yeah. And people make the mistake of you write a will, then you forget to name executors. So now, in the process of enforcing, the court has to ask, so, okay, there are instructions here. Who is supposed to carry out these instructions? And then now there's a process of appointing the executors. So it is important that you appoint your executors in your will and you inform them. You don't have to tell them everything. I have given so and so this and this. Just tell them, I have named you as my and that is a practice I do. I will usually ask the client, can I communicate? Let me call you. Can I give me the contacts of the executor? Let me call them. Let me explain to them what you have done. And so that they know that there is a responsibility.
Because it's a big responsibility.
It's a big responsibility, and they need to understand. And the importance of communication is that also someone understands so that they can say, me, I want to check out of this. I can't do this. This is too much work you're giving me. Yeah. So it is important to communicate with them. And once the will is done, I also recommend that let me communicate with the executor as your advocate. Let me tell them so that they can also inform us when you die. Because then we won't, if they don't know you have a will, they won't know to tell us that you have died. Me, I'll just sit there with your will in my office. So it is important to communicate to your executors. So your executors are the ones who enforce your will. They are the ones who carry out your instructions.
So, to make it clear, if I'm writing the will, you called me the attestator.
Yeah.
And then I come to you as the lawyer to help me draft to write my will, right? And then you will store it for me and you help me seal the will. And then there is somebody who is independent of you who is going to be the executor.
Executor, yeah.
Can the executor usually who are executors? Are they family or is also a lawyer an executor?
No. It is usually mostly family. Usually family. So for instance, for spouses, it makes sense that if you are married, it makes sense that your wife is your executor. If, for instance, you have children, maybe your parents, maybe you're a single parent, you have a child. The thing we need to remember is that executors also need to be adults. So if you're a single parent, you have an adult child, they can be executor. If you don't have, maybe you have only minor children, you can choose a sibling to be an executor. And sometimes especially when we choose families, we recommend that you also get an alternate executor. We've had instances where you both go maybe to to a family thing and all of you die. You see, now there's no one left, so we recommend in the will, maybe let there be an alternate in case you and the executor you have chosen, the primary ones, are not there. There's someone else who can take on that role. So it is usually family. It is not proper for an advocate to be an executor of someone's will.
Okay.
And it can also be someone who is not family. It can even be a family friend.
Yeah.
It can be as long as they require. First of all, the law doesn't give any limitations as to who an executor can be. It's for you to exercise discretion and see, depending on my estate, how my estate looks like, the complexity of the estate, the work that is in my estate. First, it has to be someone you trust. It has to be someone who you trust and someone who has the capacity to do that work. So it doesn't still necessarily have to be family, like you are related by blood. It can be any other person, as long as it's someone who, they know you, they know your children, someone you can trust to do that work. So it doesn't have to be family, but also there's no need for it to be a professional, because it's not really professional work.
That's what I wanted to understand. I always thought that being an executor is professional work. So it's okay. Hold on.
Because even as an executor, you will need an advocate to draft for you the documents that you go with. You can't draft them. It is important that you get an advocate to draft them for you. So it's not really professional work. It is mostly enforcement and overseeing. Exactly.
Okay, interesting. Wow, that's very new information. And so out of all these writing the will, I apparently there are assets that cannot be included in a will. I hear lawyers saying probate assets, non-probate assets. So what are these things? What are probate assets and what are non-probate assets? Yeah.
So as you call them, right? There are probate assets and there are non-probate assets. So probate assets are assets that can be covered in a will. Non-probate assets are assets that will not be included in the will, even if you provide for them in the will. They will override the will. So probate assets, non-probate, let me just give non-probate assets. They are, as we said in our previous conversation, jointly owned properties. If you own a property jointly with someone, the joint ownership overrides a will. So even if you provide for it and say, I want to give my plot to so-and-so, but it's jointly owned, then there's no, it's not covered, and the bequest to whoever you're bequeathing it to will fail because there's no asset. Another one is the ones we talked about: beneficiary nominations, beneficiary designations. They are not probate assets because there's already someone who has been designated to take them upon your death. So even if you provide for them in your will, the bequest will fail, and that's why we need to underscore the importance, because you might have died thinking, I have left things to people, and then they go and then they are not probate assets, and then your people are left without anything. And that's why we said the thing about chamas, properties you've bought with friends. Go look at the title so that you don't include it in your will, and then your chama members take the joint property and you think, I have left something for my property, for my family. Another one is gifts. If you've already given a gift, a formal gift, not word of mouth gift that you don't formalize, you have done the transfer, even if you include it, it's not owned by you. And then the other ones are properties that are owned by a trust. We said in our previous conversation that properties owned by trusts are not probate assets. They override the will. So even if you provide for them, because the thing is, depending on the kind of trust you have, and I want to insist that it's the living trust, the ones that you progressively put properties while you're still alive. Even if you provide for that property in your will, it will not take effect, and that gift will fail to whoever you've gifted it to. So as we write wills, and that's why we still keep recommending to consult, remember that even if you provide, so don't sit and think, oh, I've given my joint property to so-and-so, it will fail. And then it failing means that person gets nothing. So we need to remember these things.
So there's a process. There's a process to these things, and it's very important for people to understand that you can write a will and feel so empowered, and then you find, like you said, that it's not even enforceable, right? So it's very important to do the right thing. So one of the most common questions or more that people ask is, okay, fine, I understand, you've convinced me that I need to write a will. How much does it cost to write a will?
Wow. The cost. The cost, first of all, is dependent on many factors. And the biggest factor is the complexity of the estate. Because, I mean, if you're coming to write a will where you're just saying, I have this money market fund, it has 400,000. I want this to go to my child. And maybe your child is already an adult, so there's no issues of trust or anything. Of course, it will be a very simple document. We cannot charge you the same way as someone who comes to do a will. They have tracts of land at Naivasha. They have another tract of land at Limu. Like, they have properties scattered all over. They even have properties outside the country. They have, depending on the complexity of the estate. Because again, if you remember when in our last video when you talked about the steps that you take for estate planning, even before we come to do the pen to paper or to type, there's a lot we need. All these preliminary preparations, putting together the paperwork, compiling everything, because the more complex the estate is, the more work will be involved in putting down this information and collecting the papers and just formalizing things and all that. So of course, the more complex an estate is, also the longer the will be, and you can't be charged the same way as a simple maybe one-page will for maybe like one property or one asset. So we'll not give numbers. Of course, once you contact your lawyer, you will negotiate on the basis of the complexity of the estates.
Okay. All right. And now that we have seen that for some people, the will can be a bit complex. What if I decide that, I don't need a wakili, I can do it by myself? Is it okay if I DIY my will? Yeah.
Legally, yes. You're allowed to write your own will without the help of any professional. But do we recommend? No. Not because we want work, we want your brief, or which we want. But again, from all this discussion, it's not as simple as it sounds. When you look at this process and also all the instances of invalidation of wills, the witnessing, the competent witnesses, the additional competent witnesses, the putting together the paperwork, it's not a very easy process. So for someone who doesn't have the expertise, because again, we say when we did the video on buying apartments, we give people that information and you said, if you have to do it well. Again, if you have listened to all this information and you want to plan your estate, if you have the opportunity to do it well or to do it in a very organized and watertight manner, don't do it haphazardly. We don't want you to just write a will because you've said write a will. Write a will that is well thought out. First of all, that is valid, legally valid. It has to be signed, as we have discussed. It has to be witnessed. That's the basic, the basic formality of it. Ensure that it's formally it's valid, but also ensure that it's watertight. First of all, ensure that it has included all your properties. And again, here you have to consider which are the probate ones, which are the non-probate ones. Ensure that the distribution that you do, you remember when you talked about reasonable provision, if you're thinking about leaving out a child, for instance, of leaving out someone in your estate, I think it's important to also have a discussion with your wakili. Tell them, this is the person that I don't really want to provide for, and these are the reasons. Tell them, will that cut it? So the lawyer would be able to look at the circumstances and advise. And even when you want to provide for, all your children, a professional, because again, Olive mentioned about, because we have seen all these cases and we have participated, we have litigated for people, we have seen all these loopholes, we've seen all these circumstances where people have gone wrong, we are able to bring in a lot of experience from that and tell you, here you are creating a loophole. Here you are creating a loophole. Yes, you'll still have a will, but is it good? Is it intact? Is it enforceable? Will it have any challenges? So, of course, you can DIY a will depending on the complexity of it. But the advice is get someone to have a look at it. Yeah.
Okay. And Olive, now that this is what you do on a day-to-day basis, is there anything that you feel that we should add to this conversation, like based on your experience or anything?
I will refer to our earlier conversation and say, in practice, it is important that as with any estate plan, to review your will. Based on what your objectives were for writing that will, and you come across any new circumstances that would need for you to maybe change it, because wills can be changed. We amend them all the time. So if you feel there's need to be, if you already have a will, for instance, if there's any wealth triber here who has a will, you need to look at it. Maybe you drafted it 5 years ago. You can have a look at it again and see, have my circumstances changed? Do I need to update this? Because then you don't want to end up with a will that will fail. You don't want to end up with gifts that will fail because you failed to update it.
So thank you for joining us once again. I'm very excited about where this conversation is going, because at the end of this series, we'll have had a whole proper estate plan. And of course, I have to ask, if tribers wanted to write their wills or draft their wills, are you the right people to go to?
Yeah, of course, we are the right people. Yes.
So you have a law practice we can come to?
Yes. You can come to our offices at Wanjiku and Kanyere Advocates. We are located at View Park Towers on 8th floor, Transcon office suites. You can also write to us on email. Our email address is info@wanjikukanyere.com. info@wanjikukanyere.com. You can also reach us on WhatsApp or on a phone call through our numbers. Personally, mine is 0715 934413. 0715 934413. Olive can also give us her number in case you'd want to reach her directly.
Yeah, my number is 0716 523959. 0716 523959.
Okay, and so thank you for joining us once again in this awesome conversation. And as always, don't forget to comment. Yeah, if there's a question you have about wills, estate planning, trust funds, please leave the comment in the comment section, because that kind of questions or feedback or any curiosity thing that you have around this conversation will help us to build this series, because at the end of the day, we're here to help you. We're here to answer your questions. We're here to solve your problems. And with that, my name is Agatha from the Wealth Tribe, and this is where we learn how to build wealth together.